Imagine pulling roughly $400,000 out of your own pocket to study and plan this massive multi-year project on land you don't even own. You pay to draw up all the blueprints, you fund these incredibly complex environmental surveys, but someone else actually holds the deed.
Right, which is, I mean, from a purely financial perspective, it sounds like an objectively terrible arrangement.
Yeah, totally.
You're taking on all the developmental risk, but with, absolutely zero statutory authority over the final product.
It really does sound crazy. But that is exactly what the Kalispel Tribe of Indians reportedly did in January 2020. And they didn't do it to build real estate or something. They did it to completely restructure the ecology of a national forest that's pressing right up against their borders.
Wow. Yeah.
So, welcome to the deep dive. Today we are unpacking episode 8, Sxʷuytn. And our mission for this deep dive is to really explore this single, profoundly complicated forest project. Because it tests the absolute boundaries of ecological restoration, tribal proposals, and even scientific consensus.
It really does.
If you care at all about how our forests are going to survive the next century, you have to understand the mechanics of this specific project.
Yeah, and because this project sits right at the intersection of sovereign tribal nations, federal law, and just intense environmental litigation, we're going to set a very specific tone today. We are going to look strictly at the documented record.
Right. Strictly the documents.
Exactly. That means looking closely at the precise legal mechanisms, the actual silvicultural vocabulary used by the agencies, and the explicit court filings. And, where the record preserves a tribe's own words, we'll highlight that.
Right.
But where we're only looking at a federal agency describing a tribe's actions, we will make that distinction incredibly clear. We aren't going to speak for anyone here.
Okay, let's unpack this because the details matter immensely here. And this entire saga, it basically begins with a letter.
A letter, right.
On June 29, 2017, the Kalispel Tribe of Indians wrote a letter to the United States Forest Service. In it, they invoked this specific piece of legislation called the Tribal Forest Protection Act of 2004.
The TFPA.
Yeah. And the tribe's goal, and we know this because their exact phrasing was preserved inside a federal environmental assessment, was to, quote, advance our shared interest in ecosystem restoration, forest health, and hazardous fuels reduction, unquote. And that's on federal land adjacent to their reservation.
That phrasing is basically the engine of this entire project, because the Tribal Forest Protection Act of 2004 is a fascinating legal mechanism.
How so?
Well, it was designed to allow a tribe to formally propose a project on adjacent federal land.
Yeah.
To protect their own tribal resources from threats like fire or disease that might cross the border.
Okay, that makes sense.
But here is the critical limitation of that law. It allows a tribe to propose the work, but it does not transfer the decision-making authority. The Forest Service still has to run the rigorous environmental analysis, and the federal government still makes the final call.
Which brings us right back to that $400,000 I mentioned at the start. I mean, if the federal government is still in charge, why is the tribe footing the bill for the environmental analysis?
Right, and that is what makes this case so unusual. It was reportedly a first of its kind.
Boy, really? A first?
Yeah. The federal agency had a massive backlog. And to get the analysis moving, the Kalispel tribe reportedly provided those funds to conduct the environmental assessment on National Forest System land.
Wow.
So the paperwork and the planning were heavily funded and shaped by the tribe's initiative, but the statutory authority to approve it remained entirely federal.
It's almost like paying to architect a house you aren't legally allowed to own. You draw the blueprints, you fund the survey, but someone else holds the deed and makes the final call.
That's a perfect analogy. And out of that collaboration comes the project's name. The agency spells it as the Kalispel Connections Trail Project.
Right.
And that word, Sxʷuytn, comes directly from the tribe.
Yeah.
It translates roughly in Kalispel Salish to connection or trail.
Now, if you are listening to this and you live anywhere near the Pacific Northwest, or you follow environmental litigation at all, you might have actually seen headlines about Sxʷuytn.
Oh, absolutely. It's been everywhere.
And if you have, there is a very high probability you've been given bad math.
Yeah, the math is completely garbled in the media.
You have probably seen it casually labeled as this 90,000-acre logging project. We need to correct the record on that right away.
We really do. We have to break these numbers down strictly. So the total planning area is indeed 90,700 acres.
Okay.
But that area is a mosaic. It is spread out across 5 interlocking ownerships. You've got private land, state land, tribal land, and federal land. Of that total, 90,700 acres, the actual Colville National Forest footprint is only between 40,300 and 41,600 acres.
Okay, let's pause on that. So right off the bat, less than half of this so-called 90,000-acre project is even on the national forest.
Exactly. And it gets much more specific than that. Inside that federal footprint, what the agency actually authorized for this 20-year project was 24,400 acres of commercial treatment.
And wait, let's look even closer at that 24,400 acres, because here is where it gets really interesting. When you look at the agency's own breakdown, only 8,800 of those acres are authorized for commercial thinning proper.
Right.
So what exactly is happening to the other 15,600 acres of that commercial footprint?
Well, that is the crux of the controversy. The remaining 15,600 acres consist of what the agency calls shelterwood and grip selection.
Okay, break that down for us.
In silvicultural terms, that is regeneration harvest.
Okay, so when you say regeneration harvest, you mean actually establishing an entirely new age class of trees, right?
Exactly.
Instead of just thinning out a few overcrowded trunks, shelterwood means you are harvesting mature trees in stages. You leave just enough of the upper canopy to shelter a brand new generation of seedlings growing underneath.
Right, you're resetting the stand.
It completely changes the age structure of the forest.
Precisely.
Yeah.
And we absolutely cannot skip over this composition, because this math right here is exactly why the environmental critics of this project have a firm, factual foothold.
How so?
Well, if your primary argument against Sxwuytn is that the word restoration is being weaponized as a cover for commercial logging, the fact that nearly 2/3 of the commercial acres are regeneration harvest is the strongest evidence you have.
Oh, I see.
The agency's own silvicultural vocabulary supports the critics' concern there. It is not just light thinning.
But again, to be perfectly clear for you listening, it is a 24,400-acre commercial footprint, of which about 2/3 is regeneration harvest. It is not a 90,000-acre logging project.
Right, that distinction completely changes the scale of the debate.
Totally. But to understand why the tribe proposed managing this land so aggressively in the first place, we have to talk about the physical reality of fire.
We do. Historically, the dry forests in eastern Washington and Oregon burned generally between 5 and 45 years.
Okay.
And just to give a localized example, Cody DeSortel of the Colville tribes has noted that for their specific landscape, the interval was roughly every 15 years.
And this brings us to a really important point about indigenous fire knowledge. It is frequently mischaracterized in popular media as this sort of mystical, spiritual intuition about nature.
Yeah, that happens a lot.
But it's actually an applied, highly specific science. It is a body of practice with its own rigorous evidence. For example, indigenous burning in this region is inextricably tied to the calendar to cultivate first foods, like camas.
Yes. Camas is a vital root vegetable for plateau peoples. And because camas flowers in the spring and early summer, putting a short interval fire on the ground at that specific time would devastate the plant.
Right.
So the knowledge isn't just, we should burn things. The actual variable of the knowledge is the timing. You apply fire when the calendar dictates it will help the ecology thrive, and you withhold it when it would cause harm.
But that precise calendar was violently interrupted by the era of fire exclusion. And the history of how we removed fire from this landscape is fascinating because it happened in waves.
It really did.
First, reservation confinement physically removed indigenous people from their traditional burning grounds. I mean, you obviously can't manage a landscape with fire if you are not legally permitted to walk on it.
Right.
Then you start seeing legislation. In 1874, British Columbia passed the Bushfire Act, which explicitly criminalized indigenous burning.
Though it is worth noting, on the American side, researchers haven't actually found an equivalent state statute in Washington, Oregon, or Idaho that explicitly names and criminalizes Indian burning in that same way.
Oh, interesting.
Yeah, south of the border, the exclusion was driven more by sweeping federal policy than targeted state criminal statutes.
Right, policies forged by absolute catastrophe. We had the 1910 Big Burn, which incinerated millions of acres and solidified the federal government's doctrine of total fire suppression.
That was a turning point.
Definitely. Then came the 1935 10 a.m. policy, which dictated that every single fire had to be controlled by 10 a.m. the morning after it was reported.
Such an impossible standard.
And by 1944, the government rolls out the Smokey Bear campaign. Fire basically becomes the ultimate enemy of the state.
But the 10 a.m. policy didn't just stop fires. It fundamentally physically altered the architecture of the forest.
How so?
By putting out every gentle, low-intensity fire immediately, we allowed decades of small, shade-tolerant, thin-barked trees to grow completely unchecked.
Those are what foresters call ladder fuels, right? Because, I always picture a literal staircase of branches. Small trees grow under medium trees, which grow under the giant old-growth trees.
Exactly.
So a fire that historically would have just crept along the grass and burned itself out suddenly has a wooden ladder to climb straight up into the forest canopy.
That's spot on. The forest became structurally primed for massive crown fires. But despite a century of these suppression policies, the cultural practice of prescribed fire didn't vanish.
No, not at all.
And more importantly, it is actively returning to the inland Northwest today. The Confederated Tribes of the Colville Reservation are burning roughly 6,000 acres a year. Ray Entz of the Kalispel Tribe conducted a burn on the Pend Oreille floodplain in October 2022.
The Kalispel Tribe even formalized this. Their March 2017 Resource Conservation Plan explicitly mandates a reservation-wide burn program. Their own documented plan calls it, quote, the cultural practice of prescribed fire.
And what's fascinating here is watching the slow, grinding machinery of state law finally start to catch up to this returning practice.
Yeah.
For decades in Washington state, the baseline liability standard for a prescribed fire has been simple negligence.
Okay, what does that mean in practice?
Meaning, if a controlled burn escapes your property, ordinary negligence is enough to establish liability. That standard severely chills anyone, including tribes, from wanting to put fire on the ground. The financial risk is just ruinous.
But that is changing right now.
Yeah.
Effective April 21st, 2025, Washington state created a prescribed fire claims fund.
Yes.
It essentially acts as a massive backstop, providing up to $2 million per claim. And the most incredible part of this statute, it explicitly names and protects cultural burning and tribal cultural fire practitioners.
It's amazing.
A century ago, the government was physically preventing this practice. Today, the state is literally setting aside millions of dollars to ensure it.
It is a profound legal shift. But, even if the state is finally willing to ensure the matches, you still hit a massive unresolved roadblock in the scientific community before you can actually light them.
Right.
And this brings us to the core question hovering over the entire Sxʷuytn project. Is the forest actually ready to burn safely? Or, more specifically, is mechanical thinning a prerequisite for putting fire back on the ground? Or is it merely a pretext that carries commercial logging into a restoration frame?
This is the defining debate, and neither side has settled it. We've got to hold this question open. Let's look at the two peer-reviewed camps in their strongest, most robust forms.
Okay.
Camp 1 is heavily represented by a 2021 paper by Pritchard and 20 co-authors. They argue that thinning must often come first.
Right, because of the ladders.
Exactly. Their logic relies exactly on those ladder fuels we talked about. Because we let a century's worth of shade-tolerant trees establish themselves, a gentle fire simply won't kill them anymore. You have to send in the machines first to chop down the ladders, or your gentle prescribed burn will turn into a catastrophic crown fire.
It's a very mechanical, sequential view of restoration. Log the small stuff, then burn the ground.
Yeah.
But Camp 2, represented strongly by Baker and colleagues in a 2023 paper, flat out rejects that model. They reject the idea that historical dry forests were these uniformly open, park-like stands of massive trees.
Right. Camp 2 argues that the historical forest was heterogeneous. It was varied, messy, full of dense patches and open meadows.
Exactly.
So to them, the deficit in our forests today isn't a lack of chainsaws. It is purely a deficit of gentle fire. They argue that mechanical thinning is not scientifically required to restore the landscape. If we just put low to moderate severity fire back on the ground, the fire itself will do the necessary sorting and thinning naturally.
So you have two deeply entrenched academic camps. Machines then fire versus fire alone.
Right.
But here is where the reality of the tribal position absolutely shatters any neat categorization of these academic camps.
Oh, this part is wild.
If you are a critic who views mechanical thinning purely as a pretext for the timber industry, you really have to grapple with the legal actions taken by tribes themselves. In August 2021, the Colville tribes actually sued the United States government for breach of fiduciary duty.
And the reason for the lawsuit is staggering. Roughly 800,000 acres of their reservation burned in the decade following 2015.
800,000.
The tribe went to federal court to argue that the federal government had a duty to mechanically thin and manage those fuels, and that the government failed to do so.
Right.
They sued the government for failing to log and burn enough. You cannot fit that tribal position neatly into a binary of fire alone versus thinning as a logging pretext. The lived reality of managing a landscape facing catastrophic fire is infinitely more complex.
Which brings us directly to the climax of this Sxʷuytn project. After years of planning, tribal funding, and environmental analysis, the project hit the courts. In May 2024, an environmental organization called the Alliance for the Wild Rockies sued to stop the project.
And this leads to the court ruling that unravels the entire flowchart.
It really does.
On September 16, 2025, federal judge Rebecca L. Pennell issued her ruling. She vacated the Forest Service's approval of the Sxʷuytn project and remanded it back to the agency.
Basically threw it out.
Meaning she threw the decision out entirely. But, when I first read this, I assumed she must have sided with the fire alone scientists, right? Did she rule that the thinning was ecologically harmful?
No, she didn't rule on the science of thinning or the necessity of ladder fuel reduction at all.
Really?
Yeah, she ruled entirely on the paperwork. The fatal flaw was a procedural mechanism the Forest Service used called condition-based management.
Okay, let's unpack condition-based management, because this is where the friction between a living ecosystem and static bureaucracy actually happens.
Definitely.
The Forest Service tried to use this method because a forest is a living, breathing thing. It changes, the trees grow, the underbrush shifts. A storm might blow through between the time an agency draws a map and the time a chainsaw actually starts.
Right, it's dynamic.
So instead of drawing exact unit-by-unit maps of exactly which trees would be cut where 5 years in advance, condition-based management describes the conditions under which cutting will occur. The agency argues this is better science because it allows them to collect accurate data on the ground right before they do the work.
But NEPA, the National Environmental Policy Act, which is the bedrock law governing this process, does not easily accommodate that kind of dynamic flexibility.
No, it doesn't.
NEPA requires the government to publicly assess environmental impacts before acting, and the judge ruled that this condition-based method violated NEPA.
Because it was too vague.
Yes. She determined that because the maps were based on conditions rather than exact coordinates, they were just too vague. The public could not look at a piece of paper and tell exactly what would be cut where. Therefore, the environmental analysis was legally insufficient.
So what does this all mean? The tragedy here isn't just a procedural failure. It's that our legal framework demands a rigid certainty that nature simply cannot provide. Let's synthesize the profound irony of this outcome for you listening. A sovereign tribe, the Kalispel Tribe of Indians, initiated this project to protect its borders. They invoked a federal statute, the Tribal Forest Protection Act, exactly as Congress intended it to be used.
Exactly as intended.
They reportedly leveraged $400,000 of their own funds to help the federal bureaucracy get the work done. And 4 years later, a federal judge threw the entire multi-year project out.
It's just staggering.
Not because the tribe's restoration idea was fundamentally bad, and not because the ecological science was proven wrong, but because the federal agency's chosen method of drawing maps didn't satisfy the paperwork requirements of NEPA.
The tribe bore the total crushing cost of an agency's procedural failure. And that brings us to the final and perhaps most delicate fact of the documented record.
Yeah.
Following the vacatur of the project on September 16, 2025, there's been no replacement analysis issued. There's been no appeal documented as of August 2026. And most importantly, the Kalispel tribe has said absolutely nothing publicly about the ruling.
Not a single press release, not a single public comment.
None. And as we stated at the beginning of this deep dive, we must explicitly name this silence as a silence and nothing more.
Right.
We are not going to interpret it, we will not fill it, and we will not guess what the tribe is thinking or what their future strategy might be. To convert their silence into a mood or an assumption of defeat or planning would be to speak for a sovereign government that has purposely chosen not to speak. The documented record simply ends with that silence.
It's an incredibly heavy place for the record to end. But it brings us right back to you and why we went on this deep dive today. If you care about how our forests are going to survive the next century, you have to look past the easy buzzwords of restoration or logging. You have to look at the actual mechanics of how decisions are made and how they fall apart.
You really do. You have to understand the precise acreage, the specific silvicultural definitions of shelterwood versus thinning, and the intense friction between dynamic ecosystems and rigid procedural laws.
Exactly. So I want to leave you with a final thought to mull over. If a sovereign nation can follow every single established rule, if they can leverage federal statutes exactly as intended, if they can even financially support the federal bureaucracy to do the heavy lifting, and they can still have their vital multi-year project completely erased by a courtroom debate over an agency's mapping methods, how functional is the concept of federal co-stewardship in practice?
It really forces us to ask whether the immense bureaucratic scaffolding around these environmental laws actually supports the intent of the laws themselves, or if it simply guarantees gridlock while the forest continues to burn.
Thank you so much for joining us on this deep dive into episode 8. Like and subscribe. It really helps the channel reach others.